In 2014, the United States Senate released a 6,700-page report on the CIA's detention and interrogation program. The full report has never been made public. The 525-page summary contained findings so severe that 5 former CIA directors publicly disputed it before it came out. What was in those pages was not a theory. It was the CIA's own records, cables, emails, internal assessments, documenting what was done, where it was done, and what it produced. What it produced was not what they told Congress or the president, and some of it has never been acknowledged at all. After September 11th, the CIA was under extraordinary pressure to prevent the next attack. Director George Tenet asked for authority to go beyond the Army Field Manual. The request went to the Office of Legal Counsel inside the Department of Justice. Deputy Assistant Attorney General John Yoo and Assistant Attorney General Jay Bybee drafted memos that redefined torture. Under their framework, pain had to approach organ failure or death to qualify. Yoo argued the president's commander-in-chief power could supersede domestic and international constraints. Interrogators acting in good faith under OLC guidance would be immune from prosecution. The National Security Council reviewed and approved the framework. Congressional leadership, the Gang of Eight, was briefed. Authorization ran from justice to the CIA to interrogators in the field. This was not hidden from government. It was hidden by government. The torture memos became the program's legal foundation. A system was built, and it would need places to operate. Places where none of the rules applied. It wasn't just techniques that were authorized. It was a kind of place. Officially, they didn't exist. The CIA called them black sites. What happened inside them is described in language so clinical it takes a moment to grasp what you are reading. The Senate documented CIA detention facilities in at least 8 countries. Sites were chosen outside U.S. territory to avoid American courts and habeas protections. Rendition flights moved detainees through a hidden network. Detainees were held in complete darkness, subjected to continuous noise, kept in stress positions for extended periods. Sleep deprivation reached and sometimes exceeded 180 hours. They were slammed against a flexible wall to maximize shock and noise. They were waterboarded. The report documented procedures like rectal rehydration without medical necessity. Complete isolation for months. CIA officers raised objections in writing. Some refused to participate. Those concerns were overruled. 10 techniques were formally approved by the Department of Justice. Attention grasp, grabbing the detainee by the collar and pulling them close. Walling, slamming against a specially constructed wall designed to flex and make noise. Facial hold and facial slap, described as non-injurious. Cramped confinement, a large box to stand, a small box where you cannot. Stress positions, physically painful stances held for long periods. Sleep deprivation, approved up to 11 days, exceeded in practice. Waterboarding was called simulated drowning. The sensation is drowning. Khalid Sheikh Mohammed was waterboarded 183 times. Abu Zubaydah was waterboarded 83 times. A physician was required to be present, cited as evidence of control. Professional bodies later found ethical violations tied to participation. Clinical language masked what these techniques actually did to human beings. The justification was simple. This saved lives. The Senate spent 5 years and $40 million testing that claim. What they found should have ended careers. It didn't. The committee's central finding: the program did not produce unique intelligence that prevented attacks. Case by case, the CIA's cited breakthroughs were obtained before enhanced interrogation through conventional means or not verifiable. The report found 20 cases where effectiveness was misrepresented to oversight bodies. 5 former CIA directors and 6 deputies disputed the findings. They argued methodology was flawed and officers were not interviewed. But the Senate relied on CIA's own contemporaneous records, cables, emails, after-action reports. Not memories years later, but documents written as events occurred. The Senate said the program didn't work as claimed. The CIA said the Senate was wrong. The CIA's own documents were the Senate's evidence. Make of that what you will. A formally authorized program tortured people across 8 countries, produced disputed intelligence, misled oversight, and saw at least 1 detainee die. What happened to the people responsible? In 2009, Attorney General Eric Holder appointed prosecutor John Durham to investigate potential criminal conduct. In 2012, Durham closed the inquiry without charges. His rationale: insufficient evidence for conviction given the legal framework in place. Officers acted under legal authorization. That authorization functioned as a shield. John Yoo, the memo author, is a tenured law professor at UC Berkeley. Jay Bybee, who signed them, is a Ninth Circuit federal judge, appointed for life. George Tenet received the Presidential Medal of Freedom in 2004. Jose Rodriguez, who ordered destruction of 92 interrogation tapes in 2005, was not charged. He wrote a book. Those tapes documented sessions with Abu Zubaydah and Abdul Rahim al-Nashiri despite preservation requests. No charges followed. Enhanced interrogation did not emerge from nowhere. Techniques were reverse engineered from SEER, training to resist coercive interrogation. SEER drew from Korean War-era research, part of the same lineage as MK-Ultra. Methods designed to help Americans survive torture were inverted and applied to detainees. Former detainees continue to seek accountability through the courts. Gul Rahman died in a CIA black site in 2002 after cold exposure and sleep deprivation. No one was charged. The full 6,700-page Senate report remains classified. Multiple administrations have kept it that way. The torture memos were withdrawn, but no federal court definitively ruled the framework unconstitutional. The precedent and the knowledge persist. The CIA's program was authorized by justice, briefed to Congress, overseen by the NSC, and documented in 6,700 pages. It operated in at least 8 countries, subjected at least 119 people to techniques the Senate called torture, and killed at least 1 person without prosecution. The 525 pages released took 5 years and $40 million. The other 6,175 pages exist. You just can't read them. History's dark archives. The documents are real. The redactions are too.